Well, good afternoon, everyone, and welcome to our November POGO session, which is entitled Ready for Action, the new Procurement Act 2023. It's lovely to see so many of you here. This session is being recorded, so please bear that in mind. The recording will be available on our website at a later date. This session has something of a celebratory feel, really, that this much anticipated piece of legislation is now enacted and is due to take effect from 2024. Those of you who've been coming regularly to these POGO sessions will know that we've been involved in responding to the consultation on the initial Green Paper and then the consultation on the regulations. And I know that many members of the group as individuals were also involved in responding to those consultation exercises. And of course, Rory's been heavily involved in the Open Contracting National Action Plan, which he might say a bit more about later. So this feels like something, a journey that we've all been on for some time, and it's finally here. And we have a wonderful lineup of panelists to talk to us about the Act itself and what's going to happen, what changes are going to be coming in from different perspectives. So Michael Bowsher, KC, Kate Gough, Gavin Hayman, Darren Node and Lindsay Maguire, a barrister, a solicitor, the Open Contracting Partnership, local government and central government. So we've got a wide range of different perspectives for you this afternoon. Without further ado, I'm going to turn to our first panelist, Kate Gough from Freshfields.
Good afternoon, everybody. It's good to be here. The point that I was planning to cover in my quick 5 minutes was the approach in the Act to remedies. And the reason I'm going to cover that is because I act predominantly in my practice on remedies and access to remedies in the context of the award of public contracts. The range of those kind of awards covers mainly contracts previously under the public contracts regulations, but also some under what was utilities contracts regulations and some defence contracts. No, that will all now be subsumed under this new regime. And the reason why I wanted to talk about that is because I hope and believe there'll be lots of discussion on this session about all the fantastic changes that have been made in this Act and all of the quite considerable work that has been done to improve public procurement out with the constraints of the overarching European legislation. And I think we should take as read that I think that's correct. But what I am concerned about, and a point I think that would be good for us all to be discussing is how we can access remedies in circumstances where things have still gone wrong. And I think particularly in circumstances where there's going to be quite a lot of uncertainty in the first few years. And I know that the Cabinet Office and Lindsay's team are working very hard to make sure there's lots of guidance out there and lots of training happening. And I want to hear about that. But I think the reality is that there will be legal uncertainty, not least because we're moving from historic terms of art and also historic European approach to things that's quite well tested now. So I think that the remedies regime is going to be very important. And I think that it's going to be important for everyone to get to grips with it. So whether you're coming from a contracting authority perspective or, sorry, there's someone saying they can't hear. Can you hear, Anne? Yeah, okay. From a public contracting authority perspective, but also from a bidder's perspective. And I think the fundamental point that I wanted to make and open up for discussion is that there has not been a significant change to the remedies regime. There was early on in the consultation process, a lot of discussion, very interesting discussion about whether or not we should set up a specialist tribunal approach, for example, like you have in the Competition Appeals Tribunal, whether or not there could be a very real shift to pre-contractual remedies. And I think that's important because, challenges to these decisions are frequent. Now, on the one hand, that is good because it means there is a robust process in place to hold everybody to account. But on the other hand, that is not good because it takes considerable public money and time to deal with these challenges, and also quite often to pay out damages, so pay out money to the disgruntled bidder in addition to the cost of the contracts themselves. And so I think that this is going to be an area where, despite all the significant improvements in the Act, there will still be some issues to think about in terms of use of public money and focus of public funds. So the first point is that the main way of holding everyone to account under the new Act is still what are called civil proceedings. So you still have to go to court ultimately and issue a claim. And the court you'll still go to, although you could still do something called judicial review, but primarily is the Technology and Construction Court. And you have to go and you have to issue proceedings and you have to pay £10,000 to start a claim. Now, that is a significant hurdle for many, many procurement processes. There is also now some very new legal tests under Part 9 of the Procurement Act. For example, tests around when the court will keep in place what's called the automatic suspension, so keep in place the stop on the ability for the contracting authority to enter into the contract, which is very important to many disgruntled bidders and also many contracting authorities. And that a test will still be being applied by the same judges in the same court. And although it is different, it is very, very close. And I am unclear whether or not there will be a real shift in approach from the judiciary when applying that test. And my understanding, and I'm very happy to be corrected, is that as yet, there has not been any significant guidance given to the Technology and Construction Court, or any significant engagement with the Technology and Construction Court in relation to the new bill. Although I did hear last week from one of my contacts that somebody was going in to speak to the judges about how we could do this better and what guidance they might need, which is very encouraging. So my concern is you still have the same remedies broadly, you still have access to the same court broadly, and you still have the same people applying the legislation. And they may try, and they are incredibly intelligent people, and they're used to applying different things, but they are still applying very, very similar legal tests in the absence of a significant shift in approach and significant guidance. So I think that that all, for me, comes to kind of conclude that I think that we are going to have to spend some time looking at how we do move within the parameters of the Procurement Act to a system of effective remedies, how we shift approach away from focusing on damages being an adequate remedy for bidders. And that has disadvantages for bidders, but it also has disadvantages for us as taxpayers and use of public funds. And what there is scope to do now within the kind of guidance and approach and discussion to really think about where real change can be made to move to a system of effective remedies, particularly where I think we are all going to be in court quite a lot, which I know is not anyone's intention, but I think is the reality of a new legislative regime that is untested and is now uncoupled from the European principles that have always underpinned it. There's my 5 minutes, Anne, to time.
Fantastic. Exemplary timekeeping and a great set of issues to raise, which I hope will prompt lots of discussion. We'll move on now to hear from Michael Bowsher, Casey.
Thank you, Anne. I'll try to be as equally punctual. These are vaguely related points. Firstly, we have obviously been discussing this Act for some time, and we've had the benefit of a lot of free statutory material, and there will be a lot of training going on. It is worth remembering, though, that when it actually comes to court, this pre-statutory material will have a barely negligible value in interpreting the statute. The rules on interpreting statutes don't go far beyond the words of the statute. I mean, and occasionally one can reference a little bit of preparatory material, but it doesn't help much, and we are stuck with what the words mean. And I was struck very much this when speaking on the significance of the change from MEAT to MAT a few weeks ago, when one of Lindsay's colleagues made the point of suggesting that the change was not as great as much of the publicity might suggest. And I think there's a lot in that, if you just read the statute, it doesn't immediately strike one that there is a huge difference between MEAT and MAT. We may all jump up and down and say it's terribly important that E has gone, but it may not be as significant as all that when it comes to be read by a judge. These are all the things which we will have to iron out in ongoing disputes. I'm going to stick on to some extent on the remedies related material, but say that it seems to be the really biggest change here, and it may turn out to be, well, again, we'll have to see, but potentially the most radical change here may be the statement of objectives set out in the legislation, because it's just worth setting out in section 12, because it's worth recalling that the courts have always struggled in this country with understanding what procurement law is really for. Probably the best synopsis is Lord Phillips in the Law Society case many years ago, but they usually come up with a sort of combination of it's something to do with the internal market, with a little bit of fairness and equal treatment, but that's about it. And it's very much a set of issues that are bidder against bidder related. And that is important and was recently very important when, in the Good Law Project and Public First case in the Court of Appeal, the then Lord Chief Justice threw out at the end of his judgment his view that these sorts of cases probably should, he made it pretty plain that he didn't think that these sorts of judicial reviews should be getting permission, because procurement law is about bidder on bidder disputes, the sort of disputes which we're used to and which Kate was referring to. And in that context, the interested party, the NGO or whoever, or the civil society actor, doesn't have an obvious right to have a look in. I mean, I'm going to leave that with that's a debate we can have, although there's perhaps only 12 months left in which that debate is relevant under the current legislation. But that is an open point. Things that seem to me are radically different when you have section 12, because the focus now includes a whole range of objectives which must unarguably, I would have thought, engage wider society. We're familiar with them: delivering value for money, maximizing public benefit, something which I think when you strip all the words out is called transparency; integrity, something else which when you strip out all the words is equal treatment; and promoting SME policy. Now, at least half of those engage interests of entities beyond the bidders who are going to be involved in a procurement. It involves the wider purpose of procurement in society, whether that be simply whether or not the contract is or is not going to deliver the health services that are required, or is it going to meet some wider social policy. So I think one of the first important questions is going to be, to what extent this change in focus of the legislation changes the ability of a much broader range of people to bring challenges for a broader range of purposes. And then, of course, where is that going to happen? Because it wouldn't obviously happen in the forum which Kate has been referring to, the private litigation field, where the Technology and Construction Court has been used to dealing. And then, just to throw in a further complication, that there is at least one other area of new litigation which is expressly contemplated by the Act, and that is debarment litigation, which is expressly referenced. We're going to have a whole set of different disputes. We will have to decide that those are going to be resolved in the High Court, but there's nothing in the Act to tell us how that is going to be dealt with. And presumably we're going to have rules of court that allocate where and how those disputes are going to be dealt with. And as one knows from the US experience, debarment in itself becomes a whole separate sector of procurement law, distinct from bid disputes. Much more to be said, but I'll stop there.
Fantastic. Thank you, Michael, for that stimulating discussion. We'll move straight on to hear from Gavin Hayman from the Open Contracting Partnership. Gavin.
Thank you so much. Thank you for inviting me here today, everyone. Hope you can hear me okay. So I'm honoured to lead the Open Contracting Partnership. Our kind of mission is to open up and transform public procurement around the world. So I'm going to tilt more towards giving a kind of digital and data-driven perspective to complement all the excellent kind of legal analysis we're getting from other people. So I think the Cabinet Office itself nails one of the key problems the Act is meant to solve in their paper on our transparency ambition, right? They said that there was no single picture of procurement in the UK. There's disparate, disconnected data sets. There's a genuine lack of organizational identifiers in that information. And there's an awful lot of information, but very little insight and analysis that you can easily extract from that. And given that we're talking about 1 in every £3 of public spending, right, that's a pretty kind of shocking situation, right? Particularly if you want public procurement to serve these social ends, you want to go green, if you want to encourage entrepreneurship and innovation. So I guess my comments, I'm going to make 3 points about how the Act's done in addressing that problem. So there's a big caveat here that a lot of the information around the notices and everything else will be in the statutory instruments, and they're still being consulted on. You could argue a lot of the Act depends on secondary legislation, and maybe a little bit too much, to be honest. But firstly, I would say I really like the new notices, right? And the focus on collecting information across the entire commercial cycle of public procurement in the Act. I think that's a really important and significant shift. The UK government and others are thinking holistically about collecting all the information across the board. If we don't have the pipelines and the pre-engagement, it's going to be, it's going to be a real challenge to involve more businesses and improve competition. So I think that's really important, and we shift away from that, shift away to that perspective of looking at this now as a marketplace and understanding how it's functioning and how it's delivering kind of better social value, rather than just collecting lots of information on atomized procurement kind of awards information and so on. So it's going to be really important, if you want to achieve that, the new notices are constructed in the way that gathers that information that's useful for the marketplace. So to give you an example, if you want to understand patterns of competition, whether SMEs are included, we need to make sure that we actually collect the number of bids that happens. Again, if we want to understand with whom we are doing business and who's actually being excluded, if I'm a local council, I want to understand SMEs who are bidding on contracts and not getting them, I then invite them in to educate them and give them more support and capacity building so they can win contracts in future. I need to understand who's been bidding. So again, collecting that information on who actually bid and didn't get contracts could be really helpful if we want to improve the health of the marketplace and everything else. So overall, I think notices are great. I just think how we construct them is going to be really important. And also the quality and timeliness of the information, how they get published, will be really important as well. And I think generally UK authorities can do a better job on that. At the moment, I think the transparency work feels like a really kind of an additional burden on already very busy authorities. They do a lot of data entry and get very little back in terms of useful information. So the transparency kind of happens over there and it feels extractive and feels of secondary importance. So I think how we feed that information back to procurement authorities to really help them do their job better is going to be the crucial kind of way that we drive change around that kind of marketplace perspective and better information and better insight and analysis in the UK. And that's going to take me on to point number 2, which is about the new digital platforms. Now, they're only very, very lightly sketched out in the actual Act itself, but there's a lot more about them, obviously, in the Green Paper and the Our Transparency Ambition Paper and everything else. They're going to be absolutely vital to deliver on this promise, right? That having a single point of registration where people prove their credentials once and have an evidence locker and can bid on all government contracts could be a huge time saver, right? I know Korea said that in their CONEP's EGP reforms, they have a consistent EGP, which I dream that we'll have one day in the UK. But they said that it saved government around $2 billion per year in time. It saved businesses around $8 billion in time in terms of bidding and winning contracts. So it's the start of the UK moving towards using better digital tools. I'm kind of excited by that. We need to make sure we've designed them to be as user-friendly and as helpful as possible to people actually doing procurement. So, for example, you get, if you're a local county council, let's say Essex, for example, you get your own like analytical dashboard with your major contracts on there, who's bidding, who's winning, what the state of completion is, what notices have been filed, what's missing, those kind of things. So I think we can do so much more with our tools and BI and everything else. And I see there's a couple of questions popping up there that maybe Lindsay from the Cabinet Office can answer about who's actually designing these tools. The one thing I would say is I know there's a lot of work going on behind the scenes about these. I think this community of POGO will be power users of that information. So I'd love to see more outreach and engagement, right, with the community here about what is it you want to see in terms of the digital tools, and what is it, the information you need in terms of notices that will help you do your jobs better. So I think that's a really important part of us moving forwards to really unlock the value of that single source of truth in UK procurement. It's not rocket science. I see amongst the people attending this call, you have Nicholas Panagos. Nicholas was the Deputy Director General of Compra Eficiente in Colombia. He led on Colombia's digital transition. It has amongst the best digital information in the world, right? If Colombia can do it, if Dominican Republic have a BI dashboard with red flags integrated into their procurement, why can't the UK? It's not rocket science. I'm excited to see us get there. I think the Act is a step in the right direction. That investment in digital platforms now as an investment, not a cost, but an opportunity, is going to be incredibly important. And my third and final point, to keep time, is implementation and change management is going to be absolutely key to this. And particularly, as Michael was alluding to, if we're moving to this culture of most advantageous tender, how we integrate that learning and development offer to really power up that change is going to be vital. The other thing that's going to be vital is the powers under Part 10 of the Act, right, which is about procurement investigations. So how you use like smart, let's call it insight into the market analysis to drive better performance, to work out who's doing a good job and have them share their experience with others. So we're raising the standards of everyone is going to be incredibly important too. So properly resourcing the Public Procurement Review Service, as I think it's called, and as the Act alludes to, is going to be super useful for driving change. It's the number one thing I think that's driven change elsewhere in the world that we've seen. So with that, I will stop. I know there's loads more exciting points to make, but thank you very much.
Fantastic. Thank you, Gavin. And a great challenge to us to think about what data we need and can make use of. We're going to turn now to Darren Node from Durham County Council for a local government take on what's going on.
Thanks. Yeah, thanks for having me. I was very upbeat till about 10 minutes ago and now terrified. So I'm going to give you a bit of an insight from a practitioner's viewpoint. And I've got to be honest, from my side, I mean, we spend about 700 million quid on goods, works and services. I think this is a real game changer. It's a super opportunity if people grasp things. So I'll give you the upside and then maybe some of the challenge that I see from a practical point of view. So upside for me, simplicity. We've got a single set of rules, which is much better than we've had before. Flexibility, we'll have 3 procedures with the, what I refer to as the game-changing, competitive, flexible procedure. And that's going to enable us to design processes that are right for the project, right for the market, rather than sometimes having to try and squeeze a procurement into, a restricted procedure or a competitive procedure with negotiation. And I do think the competitive flexible procedure is going to give procurers practically a really big opportunity to innovate and deliver better outcomes. Having led social value nationally for the LGA for 7 years, I was most delighted to see the National Procurement Policy Statement in Section 13 of the Act. And interestingly, whereas the Public Services Social Value Act only has a duty to consider putting social value into a project, Section 13 means all public procurers must have regard to the National Procurement Policy Statement. And even though the word social value are only mentioned once in the Act, if you actually look at the main objectives that UK government are seeking to achieve, it puts social value front and centre, and there's a harder legal test there to evidence that you've had regard to rather than just consider, which I think is really positive. I think a lot of good procurement organisations already do preliminary market engagement, but some people shy away from it because, you know, the rules currently don't really actively encourage it, whereas expressly now they do. So I think that's going to help us to design better projects. The supply base is going to be able to come forward with ideas and solutions, as well as influencing the process to see how that might move forward. And, you know, quite pleased to see the issues about some of the supplier benefits that we should see, you know, particularly in the areas of maybe small, medium enterprises and third sector organisations, where we as procurers will be encouraged to eliminate or reduce the barriers of entry in procurement projects. So I think that's really positive. The transparency agenda, I've got to be honest, I wasn't delighted when I saw 13 notices from an administrative burdensome point of view. Nevertheless, on reflection now, I'm actually changing my mind and I'm quite pleased. You know, and I share some of Gavin's optimism. So those 13 notices will be quite onerous for procurement people. There'll be a resource requirement there to populate them and populate them well. But I think in due course, via the single digital platform, and it will take some time because you need data to go in to enable data to come back out again. I do think we'll get better data to inform future procurement strategy. I think in terms of some of the challenges, obviously the training and education, as Gavin mentioned, is quite crucial, both buy side and supply side. Practitioners and the supplier markets are going to have to learn a whole new language. Pipeline notices, preliminary market engagement, participation periods, and so on. One of the things I've thought about, and I'm not quite sure the way this is going to land. So if you start a procedure under the current rules, you finish it under the current rules. And obviously, if you go with the Act, you will follow the new Act. So will that mean that a lot of procurers will go early now and flood the market with opportunities to put contracts in place using the procedures that they know and love or like? Or in contrast, might it actually restrict people and people will sit back and do not a great deal between now and October and wait for the new Act to come in and follow the new procedure? So jury's out on that one for me. So, you know, we'll have to watch and wait and see on that. I think also one of the issues, I think, will be risk aversion. Cabinet Office have done a super job with this throughout the whole process and given us, particularly the competitive flexible procedure is, you know, a real game changer, as I've said. But will people resist? Will people just fall back on competitive procedure with negotiation and restricted? Or will they grasp the nettle and try and be innovative? And again, you know, we'll see how that transpires. And I do think there'll be challenges for bidding teams. Bidding teams now know the rules, know the processes, they follow them. The steps are set out, the timescales are set out. Every single competitive flexible procedure now potentially could be very different. So that's going to make it more of a challenge for the bidding teams, and they're going to have to be trained and educated, because we in local government have spent years getting markets bid ready, and we're going to have to do that all over again. So there's a resource implication there, but obviously there's an incentive to do it to make sure we get better bids. And I think to conclude, overall, as a procurement practitioner, I'm absolutely delighted with the outcome. The process has been good. The outcome is good. It represents a great opportunity, notwithstanding some of the technical issues and legal issues that we may have to face in due course. And, you know, genuinely, I hope that procurement officers do grasp the nettle and try and do innovative things. Thanks.
Fantastic, thank you, and great to hear so much enthusiasm, I think, for what's about to come. Last but by no means least, Lindsay McGuire from the Cabinet Office.
Hello, hi, thank you. Hopefully you can hear me okay. So I'm not used to being in this position because normally I go first and set the strategic kind of direction of everything that we're doing. In this instance, I've got millions of notes on how to kind of come back on everything that's just been said. So I'm in a new position, but actually this is why I thought it's a brilliant session to come and join and actually get some of this feedback. And there's loads of chat going on, which I'm really grateful for. So I'm not going to go through detail because I think that's all been said, and all of the points that have been raised are really valid, and to be honest are things that are on our radar. So throughout this whole process we've been very clear that the Act is kind of only the beginning. Like it's a framework. I know it's important, I know it sets the parameters of everything that we're doing within procurement, but actually all of the ancillary stuff, the learning and development program that we're developing, that we're spending time and money and engagement on to make sure that people have got what they need to navigate the change, that's really important. The platform, as Gavin's mentioned, which is, and I can answer in a little bit more detail, it's an enhanced find a tender service. So basically we're taking find a tender, we're ironing out all of the challenges that it's got at the moment, and we're repackaging that so it will meet everyone's needs. Now, I know that there is a little bit of a gap of information at the moment which people are filling. So we are, sorry, I don't quite know what's going on behind me. There's some kind of photo shoot going on. But we are quite conscious that we want to make sure that everyone's got the information of everything that we're working on so that you can take that away and prepare going forward. I do think that a lot of the challenge that we've got at the moment is how to phrase this, is bringing in a level of pragmatism around some of the commercial decisions that need to be taken now versus a lot of the messaging which is political and big bang and everything's going to change and it's a once in a generation. It is a really important transformation, but the reality is, as Darren said, we're going to be operating under two regimes for a little while. We're still going to have the ability to do call-offs under the existing regime. We want to build up the data in a database so that in 4 or 5 years' time, you'll have a really good picture of what's happening and how money's being spent. But these are long-term changes. And I think Darren made a really good point that one of the things that we're most worried about is that we go through all of this and we kind of work quite hard to get to this point, but actually nothing really changes because resources and governance and structures in organizations and all of the risk aversion, everything kind of gets in the way and we revert to what we do normally. So as part of our implementation offer, and there's lots of tactical things that we're doing, like making sure that we're communicating with the right people at the right time, making sure that people are kind of got what they need in terms of user testing, prototyping, all of that stuff. And a lot of that is still to come in 2024. It's about getting what's working, where are the commercial ideas, where's the really good practice, where are there pockets of fantastic things that we can kind of share through various different forums. And that's why a lot of our learning and development offer, it isn't you do your learning and development and then, okay, fine, see you later. It's about creating that long-term change. So communities of practice. So how best can we bring suppliers into our communities of practice to tell us what's working? So, Darren, you just said about worrying about the market tensions. Is there a platform where we can get a load of small businesses, a load of procurement teams? Let's just have a conversation about what works for each party and we can kind of use some of those case studies going forward. Now, a lot of this obviously is going to take resources, and to be honest, we're not hugely resourced in Cabinet Office. We're not a particularly big team. A lot of what my team do is kind of deliver through other people. But where there are willing change agents and where people are kind of willing to come with us and take a bit of risk and try something a bit new and kind of show that commercial sort of curiosity, I genuinely think there are some big wins that we can make with this. I'll pause there because there's loads of questions, and obviously I didn't go into too much detail, but I think in summary, one of the main things that I'm kind of worried about is that behavioural long-term change that I'm really keen that people kind of come with us on this journey.
Fantastic. Thank you, Lindsay. Thank you for your thoughts and for joining us today for this session. So we've got a bit of time now to collect up a few more questions. Please keep them coming in the chat. It's great to see all of those. There'll be an opportunity in a few minutes for our panelists to address the questions, including those from the chat. But if you'd like to either put your camera on and wave at me, or ideally raise your little electronic hand, you can also ask a question in person if you would like to do so. Now you've all gone shy. Well, in that case, what we will do is go back to our panelists and get them to address some of the questions that have been coming through in the chat, which I hope people have been keeping an eye on. Kate, are you okay to go first?
Yes, thank you, Anne. And maybe I'll ask Lindsay a question at the end as well. Maybe that's unfair. Sorry, Lindsay. But the first point, there was a question about where in the Act it actually specifies that you have to go to the court for all of this. And just so that people have it, if it's helpful to them, it's in Part 9, and that refers to civil proceedings. So that means court proceedings, not criminal proceedings. And then it talks about the High Court. And that means you therefore have to go to the High Court. And then historically, as a matter of allocation, so that we could build up the kind of understanding and the capacity of the judges in the High Court, these cases go to the Technology and Construction Court. So that's why, without something specific overlaying that, and I don't think, Lindsay, the intention is anything specific, we'll overlay that in terms of the legislation and maybe guidance, that we will still find ourselves in the High Court in relation to these claims. One point that Michael made, which I think is really important, and I think might be helpful to hear other panelists on, but or other people, is this point about debarment. I think there's quite a lot of nervousness about blacklists and quite a lot of nervousness about the perception of that, and therefore having a regime around debarment that is not subject to court oversight, but some other form of oversight that's not yet clear, is making people very worried at the moment. And I think that also how the discretion in relation to debarment will be exercised, and particularly how all of that kind of from a legal perspective is kind of framed outside of an EU law background, is also something that's making my clients certainly concerned, just about understanding where the regime will be and where the risks are. Another point I think we're talking about is, do we really think there are going to be more challenges? I think we really think there will be, not necessarily for a long time, but I think that if there are procurement outcomes that people feel are incorrect or unjust or other things, at the moment there may well be more hooks for them due to the uncertainty in the legislative regime for them to be able to launch those challenges. So it's not perhaps the appetite will change, but it's that if people have the appetite to challenge, there may be better or more ways through for them whilst we're all kind of addressing the position. There is also quite a lot of opportunity for foot fault at the beginning of any new regime. And I know that Lindsay is doing an enormous amount of work with her colleagues to train people and to get all this guidance. And I completely accept that what we need is the regulations and all of that. I definitely don't want to preempt that. But necessarily, all of this is reasonably complicated despite the efforts to simplify it. And therefore, I think that we will see more challenges. Not because of the Act, but obviously once everything's enforced and we have the regulations. And I hope and believe that will settle down. But I do think people need to be making provision for that, not necessarily in their budgets, but in terms of their attitudes to these procurement processes.
Fantastic. Thanks, Kate, for those comments and clarifications. Michael, is there anything that you would like to add or respond to?
There's at least an hour's worth of response to the various questions, but let me try and do 3 minutes worth and then stop. It would be, firstly, I can't remember whose questions these are. It would be hypocritical of me to say that it's not important that this is an act, because 20 years ago, when our previous legislation was put in place, I used to bang on and say it was unfortunate that this important legislation was done by way of secondary legislation, because I certainly then thought that it sent an unfortunate message to the judiciary, actually, and I think it was seen as sort of a bit less important. It was just, you know, somewhere around there with sort of implementing legislation of health and safety at work regulations, and it was all a bit technical and not a sort of overarching key policy. I do think it sends an important message. Maybe it makes no real difference. As a matter of law, it makes no real difference whether it's primary or secondary, but I think psychologically it may make some difference to the judiciary, at least. The question about old case law is a fascinating question on which I will be publishing at some point. It's a really difficult question and unpacks a whole host of problems which the Supreme Court is currently grappling with in a number of regimes. Technically, I think it's probably the case that most of the old case law, it will be not binding, at least, and possibly irrelevant, but at the very least a lot of it will reflect the way that judges used to look at these things under the old regime, and they're likely to look at this where the question is more or less identical. They're likely to look at it in pretty much the same way, even if the words are rather different. Having said that, I will hold two contrary views at the same time. It may be that, starting where I did with the different objectives, it may be that if you look at these points with a different set of objectives in mind, it may be that you have to reach radically different answers, because you interpret, although you might have thought this was what the answer was if you were just looking at a bidder on bidder case, if you look at it in the broader context, you end up with a very different answer, because, to pick up another question, clearly the policy statements are going to be important. The way in which they're worded is important, and you know, you can have a lot of fun just comparing the wording of the English policy statement with the Welsh policy statement and thinking about how that may play out differently. And if you have a claim which is based around what will presumably be a judicial review, so in the High Court, but a different part of the High Court, applying a different test as to whether or not the contracting authority has properly had regard to social value, sustainability, other aspects of benefits set out there, you may find that you end up with some quite radically different answers from what we would currently regard as the normal approach to public procurement, given the current nature of our processes. I will stop there, frustrated that I haven't finished the 127 other things I could say.
Thank you, Michael, for your self-restraint, and we look forward to reading the articles in due course, articles plural, I'm sure. Gavin, anything to add on the digital and data side?
I see lots of interesting kind of comments, and then +1's been added and thumbs up in the comments. So people saying there's a real challenge with data quality at the moment, and some of the information not being published isn't great, like the KPI piece. Yeah, I think it was a really good analysis looking at the gaps in that. So I think exactly that thoughtful bit around data quality and timeliness as well is incredibly important. I might have frozen, I hope not. Oh, good, I'm still going, good, okay. There's a great point made by Chris Smith, and yeah, I love collaborating with Chris on certain things. Chris is making a great point there about matching the development of a single platform with better kind of e-procurement tools to use for tendering and bidding. I completely agree. I think that's a really good point. Lindsay was saying about upgrading Find a Tender. I mean, there's the basic, you can make it a bit better by containing a bit more information, and there's the more radical overhaul where you can provide it in much better sort of much more customizable formats for different users. And I hope it's moving towards the more radical in due course. So I appreciate there's a big job of just converting those notices into data, structuring that probably the open contracted data standards. One thing that was touched on in the comments is about framework agreements. At the moment, they are there's a real disconnect on the information there. So you can't often match call-offs to frameworks and so on. So there is a need to do much better modelling around that so we can understand the outcomes from the framework. So I think that's a particular thing where find a tender trying to use it currently to match the frameworks is I think virtually impossible realistically. So there's a bit more data structuring and thinking I think needs to happen there. I'm sure some of those conversations are happening, but I don't think it's just a question of a bit more of a search function, find a tender won't really help local councils do their jobs better. So how we then attach the red flags and analytics tools to that, for what it's worth, that's not a big expense, right? Because we do those around the world, and we've got a kind of open source like engines and analytics that you can use for a lot of those. I mean, as I said, we're doing it in Dominican Republic, right? For like a quite a small cost project. So I don't think it's rocket science. I do think level of ambition, should be amped up there. And I think it's our job as civil society and others to like cheerlead to our politicians and others to make sure the Cabinet Office team get the resources to really deliver on that. And I think there were some people talking about combining tussle with oxygen and stuff like that. I like the way people are thinking to get that kind of that seamless information that allows everyone to move up the value chain. And then there's another great point about the transparency burden, and there's just an incredible amount of duplication. Literally, people type it into one system, they have to go and type it into another, and that seems crazy. So the way we can unlock and share things seems really smart. I think it was a really interesting comment about Scotland as the control group. If things isn't getting better for everybody else and it's better in Scotland, then we haven't achieved our objectives. So I think that's a really smart observation by Stefan there. So I'll pause there, and any time I've got left over, please give to Lindsay to answer all the other questions. Thanks.
Yes, poor Lindsay, rather a lot coming for you in just a second, but let's see first whether Darren is still feeling optimistic. Darren.
Yeah, I am still optimistic. I mean, I'll try and pick up I did scribble a couple of things down that people haven't mentioned. Somebody mentioned about the impact of a general election. Well, this may be very naive, but for me, the act is the act. I don't imagine it changing. Perhaps what might change is the elements of the national procurement policy statement. If government have a new government or a different government has a different view on things. But if you actually look at the national procurement policy statement, it's about new jobs, it's about new skills, it's about supply chain resilience, it's about waste reduction, it's about climate change. My view of the world, particularly wearing my local government spectacles, is these things go across political colour. A lot of the politicians, regardless of the colour, are supportive of the things that are in the national procurement policy statement. So I don't expect too much change if there's a change of government. There's an interesting point on the point of the compliance on transparency. And for those of you who want to check the Durham website, I do comply, I always have done, producing the data, but it is very burdensome. And quite often the data we produce is meaningless. I think back over the last maybe 9-10 years, we've had very few questions about the transparency data that we've put on our systems. So I am quite hopeful now that these 13 new notices will provide good data, usable data, that will not only help the public, but also will help procurers. And I think the debarment issue is going to be quite interesting. One of the things I'm hopeful about, and particularly in the publication of the KPIs, is we can shift the balance away from the supply base to procurement people for poor performance. So basically, under the current regime, if I've got a really poor performing supplier, when we come to renew the contract, they can still bid. And if their bid is the best bid, they can still win. And I think it's going to be really helpful to be able to get a lot more transparency when suppliers don't deliver the benefits that they commit, or the performance of them leaves a lot to be desired. So I'm quite keen that hopefully we will see a little bit of a shift there towards the buyer. And there's a final comment, I think, about guidance on the new tender procedures. I think that's where the communities of practice are going to come in, because I think it is really important that as procurement people we get together to share knowledge and skill and ideas and successes and failures. And I also like Lindsay's idea about the supplier engagement as well, because at the end of the day, we need suppliers to understand the processes and the procedures, and from a local government perspective, we're really keen to work with people to make sure we get good engagement and good bids. Thanks.
Fantastic. Thank you, Darren. And the last word to Lindsay. 4 minutes, probably not enough for all those questions, but see what you can do.
No, that's fine. I have actually, yeah, I have actually been trying to answer them, and you're on the browser version of Zoom. It is really difficult. So I will go back in and try and answer kind of what I can. But just on the point about the election, because I was obviously going to take that one as well. I think so. An interesting quirk of the Act. It means that the Act is the Act, but there actually isn't any commencement date or powers within the Act. So that comes in the secondary legislation. So when we do the secondary legislation, we will basically be putting in this Act will go live at X. Now, obviously, that means that we've got a little bit of time to take that decision. So if, and I'm not saying that this is going to happen, I know as much as anybody else, but if there is an election that's called for May, before we do the secondary legislation, we could probably take a view as to what commencement date we would want to include in the secondary legislation. But for now, we're working for October. And I agree with Darren that actually it wasn't particularly, despite lots of debate, it's not particularly controversial in terms of the sort of opposition, and actually, I mean, I think if an opposition gets in, they would be reasonably fine with it. Where I'm concerned is less about the actual implementation of the go live, but the mitigations on departments and organizations that might have a significant shift in priorities, which might otherwise take up scant resources away from focusing on transformation. So it's quite difficult to deliver transformation when you've got, political change. That's for us to navigate, and obviously we'll be kind of communicating that as we go forward. On the point about burdens, so this is obviously really a really important one, and I get that there's lots of concern about what we're doing is sort of adding in administrative burdens. And I think part of that is because people are sort of looking at the kind of notices and saying, well, actually there's 13 notices, there's 13 new notices. But a lot of those notices do replace an element of procurement. So it's not like we've kind of significantly extended a procurement life cycle in any way. We've just added in points which should be published. So burden-wise, on pure administrative work, it might take a little bit of time to bed in. It might, need a little bit of communicating, which is obviously what my team are hyper aware about and why we've been working quite closely with lots of organisations. But actually, they're all stuff that should be kind of done with a procurement anyway. So I think there is a bit of probably hands-on sort of visual representation that we can do as a team, which will show you how this will work. Because on the flip side, what the notices do, and I think Gavin mentioned this, is it standardizes your information. So instead of writing a letter for every single supplier, you now have a template, which is, here's the information you need to provide. So it kind of removes a little bit of the burden, and it removes a little bit in some areas. But that's obviously a very difficult message to get out. So I do appreciate that resources are stretched, and procurement is often in some organisations an area which is, let's face it, faces a bit of underinvestment. So these are all things that, with that feedback, we can then build that into the communications and the work that obviously my team are doing to roll that out. There's a couple of quite tactical questions about L&D. So just really quickly, I'm conscious of time. I know I'm running out, but Knowledge Drops is our first L&D product that's coming on the 5th of December. So these are short, sharp info sessions. Share them widely. We really want everyone to have a look and see what's coming. E-learning will be coming the end of March. So this is 10 hours of learning, and then our deep dives will start May time, when we're kind of in the implementation period. So the first one, yes, so just in response to Kathy, just put that, yeah, they're on YouTube, so they're open access, basically, so they're available for everyone, suppliers, and we'll make sure that we're kind of communicating that quite widely. I think that was it, unless anyone wants to kind of nudge me and say that there are some other pressing questions in the chat which you think I should take.
That's wonderful, thank you, and thank you for coming along and being so open with everyone and willing to engage in this discussion. That kind of brings our
Sorry,
time
Anne, can I
to...
just jump in with one question, as Lindsay's given us the opportunity to? That latest
Very
PPN,
quickly, yeah.
The latest PPN on payments, it is just, I haven't met anybody in the supply chain that thinks it's a good idea in the SME sector, and I know it's come out of the budget. It was trailed in the budget, but then the PPN was obviously released just shortly after that. It would be really useful to have an understanding of that. I mean, Martin Talbot's already said that he'll talk it through with the SMEs, but there's very few of us that think that the 50 days is a good idea.
Okay, I don't know the detail, but sure, yeah. I mean, let's talk it through. Absolutely. I mean, I'm surprised at that, if I'm honest, because I think prompt payment is obviously an issue. So
it's a massive issue, but you've taken it worse than it was previously, and that's the challenge. But I'll come back to you.
I don't think we have, but let me have a look, and yeah, I mean,
Thanks.
let's take this offline. Absolutely.
Fantastic. Okay, we'll leave that discussion for another time then. So it remains then for me to thank our wonderful panel for their contributions, and also all of you for participating, and particularly for a brilliant discussion in the chat, which I've really enjoyed, and I hope it's been a helpful session for everyone. So huge virtual round of applause to everyone involved. I'm going to hand over to Rory now for admin things.
Thanks very much. Thanks, everyone. Just briefly, some of the participants in this group submitted a response to the consultation about regulations, and some of the points are there, so I've just dropped a link in there. I wanted to say that the Oxford POGO Club will continue next year. We will be looking at some of these UK implementation issues, as well as some wider issues on sustainable public procurement, including net zero. We will be having an in-person symposium in June, so a heads up on that, but we will also continue the sort of monthly sessions that tend to be on the last Tuesday of the month at 4 p.m. I also wanted to just finally draw your attention to my colleague Harry. Harry is hosting a session on enhancing green public procurement. It's a research focused session, and that's happening on December 8th. So I'll drop a link to that in the chat now if people are interested, particularly those with an academic focus are interested in this research session focused on green public procurement. But that's it from me. I look forward to seeing people in the new year at more POGO sessions. Thanks. Do you want to close?
Yeah, thank you very much indeed. That's the end of the recorded session. If anyone would like to hang out for a bit longer, some of our panel may be able to stay on for a little bit, but that's the end of the formal proceedings today.